Hi everyone. In the last video, Radhika has taken us through the history and background of the controversies relating to taxation of royalty. Today, I, Raksha Rao, Manager Direct Tax Services at Advait Consulting LLP, will take you through what all things were discussed in arriving at the conclusion by the Supreme Court in the case of Engineering Analysis Center of Excellence Private Limited versus CIT. To give the facts in brief, the company is an end user of shrink-wrapped computer software which is directly imported from USA. The tax officer found that what was in fact transferred in this transaction between the parties is copyright and thus amounts to royalty and TDS should be deducted. The appeal before CIT appeals was dismissed. ITAT followed its own previous order in the case of Samsung Electronics Company Limited passed in the year 2005 and ruled in favor of the company. The revenue went before the High Court and High Court, after examining the end user license agreement, concluded that it should be royalty and TDS should be deducted. On the same issue, various appeals were pending before the Supreme Court. This company was considered to be the lead taxpayer. All other cases were bunched together and the Supreme Court has delivered a combined judgment. Supreme Court observed that this issue can fall in any one of the four categories. First category deals with the cases where Indian end user purchases a computer software directly from the non-resident supplier or manufacturer. Second category deals with the cases where Indian distributor purchases the computer software from non-resident supplier or manufacturer. Third category deals with the cases where foreign distributor purchases it from foreign vendor and then distributes it to the Indian distributor or to the end user. Fourth category deals with the cases where computer software is affixed to the computer hardware and then the integrated unit is sold to the Indian distributor or to the end user. Now the question arises whether the payments made to foreign non-residents, being the suppliers or the manufacturers, whether it is for copyright or copyrighted article. In order to answer this, various terms and definitions used in the income tax law, double taxation avoidance agreement, Copyright Act were discussed and analyzed. It is important to understand what is copyright, what is copyrighted article, what is infringement of copyright. Let us take an example to understand this. Let us take two scenarios. In the first scenario, the foreign publisher sells 2000 copies of a particular book to an Indian distributor for reselling it to the end users. In the second scenario, the foreign publisher gives the right to Indian publisher to reproduce and make copies and then resell it to the end users. In both the scenarios, the end result is the same, but the mode in which these have happened are different. So, in which scenario there will be transfer of copyright? Discussions were done around transfer of which all rights are considered to be transfer of copyright, how that gets determined, etc. The key conditions that the user gets is enlisted in the end user license agreement. Various end user license agreements covering all the four categories stated earlier were analyzed and discussed, and the Supreme Court came out and talked about the rights of three persons. The first one being the distributor's right. So the distributor gets only the right to distribute and it is a non-exclusive, non-transferable right and he can't use the product. End user gets the right to use the product but he can't reproduce or resell it. So no copyright is transferred to the distributor or to the end user. The ownership and the title vests with the owner itself. Moving further, now let us see what all things were discussed in coming to the conclusion part. Definition of royalty and the amendments made to the definition of royalty were discussed. In 2012, royalty definition was amended by inserting an explanation 4, so as to make the consideration for use or right to use computer software is considered to be royalty. This was a clarificatory amendment to state that definition of royalty always included the computer software and that it is a retrospective amendment from 1st June 1976. Now the question arises as to whether the company is obligated to deduct TDS under section 195 for the assessment year, which is 2001 to 2002-03, which are under appeal, when explanation 4 itself was not in the statute books. To answer this question, Supreme Court analyzed the two Latin maxims. First one says, the law doesn't demand the impossible. Second one says, when there is a disability that makes the act impossible to obey the law, such alleged disobedience can be excused. On this issue, various AAR rulings, High Court rulings were discussed and analyzed. Also on the issue relating to copyright, copyrighted article, infringement of copyright, which were globally announced, were also discussed. The next issue that the Supreme Court discussed was regarding the interpretation of 18 double taxation avoidance agreements, which are the tax treaties relating to the cases pending before the Supreme Court. These DTAs are majorly based on the OECD Model Tax Convention, and the Article 12 about the royalty is also based on the OECD Model Tax Convention. But India said, without making any objections or without saying why it is objecting, it said India reserves its rights to tax royalties and FTS by referring to the domestic law. But till now, there has been no definition or no amendment has been made to the definition of royalty in the tax treaties. What is the conclusion arrived at by the Supreme Court? What is the principle emerged out of this ruling? What is the way forward? To know more on this, along with our detailed analysis, stay tuned to watch out our next video. If you have any comments or queries, you may mention them in the comment box. Thank you.